speaker. It was to be two speakers for the next session, but unfortunately one of them has not been able to come. That's Lisa Ford, who has contributed to this paper but is unable to be with us today. She's a senior lecturer in the School of History and Philosophy at the University of New South Wales and is currently working on two ARC-funded projects spanning the relationship between the status of convicts, slave and Aboriginal people, and ideas about British imperial jurisdiction in the 18th and 19th centuries. And she's been working with David Roberts, who we are fortunate to have here today. He's a senior lecturer in history at the University of New England, where he teaches a wide variety of courses on 19th century Australia. He served us all very well by being the editor of the Journal of Australian Colonial History, which is really the leading journal on that period, dedicated to that period, and is also the director of the University's Heritage Futures Research Centre. His current research is also funded by an ARC Discovery Grant on liberty, anti-transportation, and the empire of morality, and that's work being done with Newcastle University's Hilary Carey, who I'm sure would love to be here today herself, but is currently finishing a book, but also sending a lot of Facebook status updates that show that she's having a tremendous time in the United Kingdom. So we welcome David here today to talk to us about Newcastle and the transformation of penal practice in the colony of New South Wales.
I'm also a Newcastle by birth and inclination. It's wonderful to be back. I miss the place very much. It looks a little bit different outside than I remember. Okay, yeah, and apologies from Lisa. It's unfortunate because she would no doubt articulate this much better than I can. She and I are recently well down the track of a fairly exhaustive study of the Newcastle penal settlement from 1804 to 1823. And what we're particularly focusing on is the processes and patterns of sentencing which led convicts being sent to the settlement. So we're looking at who was sent, why they were sent, and who sent them. And it's revealing quite a complicated story, but also an interesting one that surprisingly seems to place Newcastle at the forefront of some very major transformations throughout the British Empire. And I'll try to endeavour to explain this today. As we know, New South Wales was the first and only dedicated penal colony in the Empire in the 18th century, in the 19th century. And as historian Bruce Kircher pointed out some years ago, it was legally both fascinating and a legally fraught experiment. In our view, keeping the peace and disciplining convict labour in New South Wales were two of the most important spheres of experimentation in the colony. What we will be arguing is that convict discipline in New South Wales exemplified and fed a very sudden transition between two different forms of punishment that were common throughout the empire. The transportation of convicts across the seas, which led, of course, to the foundation of New South Wales, began as an exercise in the King's prerogative. As Blackstone pointed out, the King could pardon people convicted of crimes short of murder on any condition he chose. And that included two quite distinct punishments. One was the punishment of transportation, which of course is exiling convicts beyond the British shores. And the other was the punishment of hard labour. Now, both powers to issue sentences of transportation and hard labour were granted by statute in the 18th century. The Transportation Act of 1718 gave British courts of record the power to transport convicts to North America. Now, an earlier act during the reign of Queen Anne, I think it was 1705, gave courts of record power to issue sentences of hard labour or imprisonment. And just trying to establish that these are two very, very distinct forms of punishment. Transportation on the one hand and hard labour on the other. Now, throughout that century, hard labour does not really emerge as a prominent sentencing option by British courts. Instead, they transport convicts overseas to North America. However, the Holmes Act of 1776 entrenches hard labour by providing convicts who are sentenced to transportation but stranded in England because of the American War could now be kept at hard labour, and whilst they were employed dredging and cleansing the River Thames. There were further acts in 1779, 1782 and 1784 which paved the way for gender-segregated work prisons for minor offenders. And by the time in 1788 when the colony of New South Wales was founded, the practice of hard labour as a sentencing option is starting to become more firmly established. And in fact, it's beginning to, for the first time, replace transportation as a common punishment for non-capital offences. So that's just a bit of background. What I want to do is look at what happened in New South Wales, because what we see essentially is a furthering of this transformation between sentences of transportation and hard labour. And it plays out in New South Wales in some very interesting and extra-legal ways. We know, for example, that the first governors of the colony were assigned property in the services of convicts, and those convicts were to labour for the public, and this is quite different to what happened in North America. But from very early on, the governors start assigning convicts to private masters, because that system proves much less expensive and far more efficient. But more importantly, hard labour becomes a key pillar in convict discipline within the colony. And it actually establishes New South Wales as a leader in the use of hard labour as a modern colonial punishment, even though when we think of convict punishment, we mostly think of flogging. It was used extensively and often in conjunction with hard labour. But hard labour is very much at the forefront of penal discipline in the colony. And what it implies gradations of labour. Basically, from the early stage of New South Wales, the lot of a convict is defined by the type of labour that they are required to perform, and the bottom rung consists of the most gruelling and punitive forms of work, usually described as work in a jail gang, often involving work in irons. In the early 1800s, such sentences were terms that were often added, no doubt legally, to an original sentence of transportation. So this is to illustrate some of the early terminology of sentencing in New South Wales. And we're talking here about a court of criminal jurisdiction, which is the only legally constituted court of record of the colony. Graded hard labour became a feature of internal transportation in the colony. The internal relocation of convicts begins within weeks of the arrival of the First Fleet. Governor Phillip, who of course had the Crown prerogative of mercy, commuted death sentences ordered on a couple of convicts in late February 1788, and he ordered that they be exiled from the settlement. And at that stage, there was nowhere for them to go, so he suggested they be taken down to the south coast and done somewhere, where he said they could serve the public by forming connections with the natives. In actual fact, they came back to North Island. But as these early examples showed, that the terminology used to describe sentences of exile was inconsistent and seemingly confused. You can see convicts are being transported to Newcastle Islands, or they're being transported to hard labour at Norfolk Islands, and various other variations. There's a confusion here very early on, which is starting to indicate that two distinct punishments of hard labour and transportation are becoming merged. Now, this melding of penal relocation or transportation and hard labour becomes most apparent in the case of Newcastle, and this is where the whole river settlement for us is standing out as being very, very interesting. It was created, of course, by Governor Philip Gidley King in 1804 as essentially a place of business, which would also serve the purpose of housing some of the colony's most intractable convicts. Now, what we see here is that sentences in Newcastle showing an increasing slippage between the terminology of hard labour and the language of transportation. If you look at graph 1, this is Ella Spence, very, very highly trained Judge Advocate of New South Wales. He issues two quite distinct forms of sentence. He sentences convicts to 7 or 14 years transportation on the one hand, and shorter sentences of 1 to 5 years, which are uniformly described as sentences of hard labour. And these, if you look at his records, the sentences of hard labour to Newcastle are very comparable with similar sentences of hard labour to the jail gang in Parramatta or to a term in prison in Sydney. Under his successor, Judge Advocate Wilding, we're looking at the bottom half of that screen, he described all relocations to Newcastle as being a form of transportation, whether that was for life or indeed for 1 to 3 years. In this way, Wilding's criminal court helps to formally define Newcastle as a site of transportation. And by the 1820s, half of all convicts sentenced by the court are receiving sentences of transportation to Newcastle. Remember, of course, these are often people who are already serving a British sentence of transportation. Now, so we've been talking about the criminal court. This is the colony's only formally constituted court of record. It's the only court that is actually empowered to sentence people to transportation. However, most convicts who come to Newcastle are sent on the lesser authority of the magistrates. And as you can see here, between 1812 and 1819, around 900 convicts are sent to Newcastle by magistrates, and that's 4 times as many as are sent by the court. And these are usually for shorter terms of 1 to 3 years, although in fact about 100 people arrive with indefinite sentences, usually described as during the governor's pleasure. Or perhaps they were sent for the remainder of their original sentence. But in most cases, they were sent for 1, 2, or possibly 3 years. Now, importantly, magistrates did not use the term transportation. They did not use that terminology, and for good reason, because magistrates, as they no doubt realised, were not allowed to sentence convicts to transportation. In fact, magistrates seem to have understood the sentencing of convicts to Newcastle as a form of relocation or labour redistribution. One former magistrate, Alexander Riley, explained to the House of Commons in 1819 that the practice of sending convicts to Newcastle was an extension of a much older process of sentencing convicts to hard labour in a jail gang in Sydney. And Newcastle was basically considered along those lines, but it was a much harsher option, obviously, and used for the particularly bad convicts. The thing about Newcastle for magistrates was that it combined sentences of hard labour with a form of exile. Even though they didn't actually call that exile transportation, we seem to get, again, this early sort of blending of those two distinct types of sentences. Most sentences, however, having described the criminal court of the magistrates, it's important to note that most sentences in Newcastle actually came from the governor himself, Governor Macquarie. He describes himself convicting convicts in Newcastle or sending them, 2 very distinct terms, but they seem to get mixed up in Macquarie's language. And this is interesting because these types of sentences were in clear excess of Macquarie's powers. I mean, Macquarie was an extraordinarily autocratic individual who seemed to insist that he could do whatever he liked with convicts who were under an English sentence of transportation. And that included the idea that he had some power to reallocate convicts to a place like Newcastle. But through these various means, about 2,000 convicts arrived at Newcastle in the 1810s. They were convicted, sent, removed under what was variously described as, and this is the language they were using, banishment, transportation, a local sentence, a fine, a colonial sentence, hard labour, or an additional colonial sentence. Now, there's obviously very, very confused terms. To a large extent, the colonial authorities don't really know what they're doing legally in sending convicts to Newcastle. But to cut it short, what basically happens by the late 1810s, there becomes this pervasive understanding that all convicts who are being sent to Newcastle are under a formal sentence of transportation. That's because the criminal court is starting to use that terminology more pervasively. Newcastle becomes identified as a place of transportation. And at the same time, even some magistrates start to describe their own sentences to Newcastle as a form of transportation. The newspapers, even Commissioner Pitt, who of course conducted a commission of inquiry into New South Wales, started to speak of sentences to Newcastle as constituting a form of formal transportation. Importantly, the terminology of transportation is hardening just as Newcastle itself, the actual settlement, is being transformed. As I noted, it was founded as a pro-industrial centre to provide coal and lime and wood, and it was always meant to be a site of sort of difficult labour. But the settlement was not well administered, as you probably know, during its early years, up until about 1815. Corruption was rife, things were very, very slack, the production of resources was insufficient. From about 1815, you start to see a major reconfiguration of the settlement. It begins most notably in mid-1815, where they actually deny convicts the right to undertake work in their own time. A very, very significant moment which differentiates Newcastle from other forms of convict work. Then, from 1816, discipline and production at the settlement were transformed by a raft of government orders issued by Walsh, who we're hearing much about today. There were longer work hours ordered for convicts who mustered late, those who were found drunk, idle, or leaving work. Convicts who reported sick began to be more closely monitored, and the sale, purchase and exchange of government provisions was prohibited. About this time, we started to see more attempts to separate convicts from soldiers, for example. And this sort of new system was upheld by the commandants like Morissette and Wallace, who had very, very extensive powers. They were essentially just magistrates, but they had the power to act as magistrates sitting alone. And as we know, they enforced discipline at Newcastle with a considerable degree of severity. There were, however, a number of reformative strategies that complemented this punishment regime. We know that convicts were required to keep orderly houses, they were required to keep neat gardens. We know that an imposing church was built on a hill that convicts were being forced to attend. A school for convict children was also established. And increasingly, they set up a system whereby release from Newcastle, actually getting yourself out of Newcastle, irrespective of your sentence, is dependent on good behaviour and a favourable recommendation of the commandant. So basically what we're seeing is Newcastle, through various means, is becoming defined more consistently as a place of extra harsh punishment and labour, very distinct from what convicts are doing in private assignment or what they're doing in government gangs in Sydney. And this was the system that was observed by Commissioner Bigg in 1820, and he largely approved of it. His observations on the management of Newcastle and his suggestions about how it might be improved laid the basis for a proposal to create a new network of penal settlements in the 1820s and 30s. Newcastle's successor institutions like Port Macquarie, Moreton Bay and Norfolk Island became greater sites of punitive incarceration and labour. It's a transformation that's driven by many key individuals, key amongst them is Francis Forbes, the Chief Justice, Governor of Brisbane had a big say in it, and also the Secretary of State, Henry Bathurst. And this all evolved despite concerns and objections that what the British were doing here is actually introducing a new principle into penal law, because they're essentially modifying and intensifying the sentences of transportation that are handed down by the judiciary in England. So the questions they were asking, was it, for example, permissible for sentences of transportation to be compounded by subjecting a convict to hard labour? They're meant to be distinct punishments. Can you actually meld them together? As late as 1837, the Molesworth Committee, the House of Commons Select Committee on Transportation, asserted that the punishment to New South Wales, transportation, is just a form of banishment. It's a symbol of how quickly the distinction between exile and penal labour collapsed. Lisa wanted particularly to make the point that this was not just an isolated development in New South Wales either. In 1824, when you start to see the Newcastle experiment being employed in other outposts around Australia, the British Empire is also employing these sorts of models in places like Bermuda. The Bermuda dockyards, for example, became a graded system of transportation like New South Wales, where you see a combination of extremely harsh living conditions with quasi-military discipline. By the late 1830s, metropolitan sentences of transportation to Australia fell into a number of categories. Francis Ford described grades of punishment or gradations of transportation. Finally, by the 1840s, at places like Bermuda, under Governor Reed, and Norfolk Island under the Connaughey, these places become acknowledged as sites of innovative prison management. And their systems that policymakers are now re-exporting to hulk establishments and prisons back home. The point we're trying to make here is that Newcastle was an earlier and much neglected progenitor of an empire-wide shift in thinking about the character of transportation. The local needs of the colony in having to punish convict labourers through relocation, combined with the need to extract resources from places like Newcastle, produced an amalgamation of prison labour, combined through distance and transportation that was exported throughout Eastern Australia and arguably beyond. In conclusion, New South Wales was a very, very strange colonial enterprise, but its exceptionalism did not make it an irrelevant outpost of empire. It led to the rise of hard labour as a colonial sentence in the British Empire, and from the 1820s onwards, it became an influential site of pan-imperial experiments which suspended between transportation and the modern penitentiary. The reception of law into this strange penal colony was, we know, troubled and complicated, but what it gave to the transformation and practice of penal law throughout the empire was also quite vital, and something that Australian historians need to better understand in order to contribute to the broader history of the 19th century British world. And we're trying to demonstrate that, above all else, Newcastle is the most fundamental case study to that broader project.